Hello and good evening in Switzerland. Good morning and good afternoon to those of you joining us from the Western Hemisphere. We are speaking to you live from New York City. My name is Oliver Haugen and I'm the manager at the Swissnex outpost in New York. Swissnex is an initiative of the State Secretariat for Education, Research and Innovation in Switzerland. And we have the mission of connecting Switzerland and North America in the fields of higher education, innovation and entrepreneurship. Together with the Swiss Commission for Technology and Innovation and with my colleagues both in Boston and in San Francisco, we run a small accelerator program for Swiss startups interested in learning more about the US market and potentially also growing their business here in the US. Our role is to provide access to customers and potential partners. We offer mentoring and advice. We have a network of industry experts that are available to assist the Swiss startups that come to the US CTI camp, and we provide office space free of charge to the startups here in Manhattan or in the larger Swissnex offices in Boston and San Francisco. As part of our services to the Swiss startup community, we offer a number of educational tools and tutorials, including this specific webinar today, which will focus on a topic of great importance to most startups in Switzerland, the issue of intellectual property rights. So to help us delve into the many complexities and the broad picture of IP rights and to look at practical considerations for Swiss startups, I'm delighted to welcome an esteemed guest and friend of Swissnex, Diane Achtal, an attorney at Rosa Bianca and Associates and an IP rights expert. So Diane, welcome and thank you for being with us today.
Thank you for having me today.
Diane, just a few words about you. You're an attorney admitted to the bar in the state of New York and in Switzerland. Your practice focuses on startups and companies in the US and abroad in the areas of intellectual property, corporate and commercial law, with an emphasis on cross-border transactions. Prior to joining Rosa Bianca and Associates in 2011, you practiced as a litigator for 3 years in Geneva, and you managed cases relating to contracts, corporate and intellectual property, and art law. You received your JD and master's degree with a concentration in art law from the University of Geneva in Switzerland. And in 2010, you received an LLM in intellectual property from the Benjamin Cardoso School of Law in New York. So in just a few moments, we are going to dive into your presentation, which is titled U.S. Intellectual Property Rights, Practical Considerations for Swiss Startups. But before that, I will make a few logistical announcements. This webinar is interactive, and the viewers will get to ask questions directly to Diane at the end of her presentation. To do so, the viewers can make use of the chat box that is on the screen on the right side of your Ustream screen. We will collate your questions and field them to Diane at the end of her presentation. Finally, I should add that this webinar will be available alongside our other webinars for repeat viewing and on our website at ny.swissnexboston.org, as well as on our YouTube channel. So now, without further ado, I will give the floor to Diane Achtal.
Thank you very much. So today we're going to go over the different intellectual property rights in the United States available. So what are the different types of intellectual property? First of all, you have patents for inventions such as machines, method, ornamental design, or plants. Secondly, you have trademarks, trade secrets, sorry. We'll go over each of them individually. Third, copyrights, which protects expressive original work, including literary, such as novels, plays, or even software codes. We will specifically speak about this later in the presentation. Audiovisual works, such as film or music, or visual works, such as paintings, photographs, architecture and design, or even web page. I will go back to web page later on when we talk about copyrights. Finally, trademarks, which protects any recognizable sign or logo or words that identify the products and the services that you offer to your customers and distinguish it from the ones offered by your competitors. Now, this is a question I often get from clients. Is an idea protectable? No. The concept or your idea about something is not protectable. An idea is just the first critical step to protection, but you need to get embodiment of this idea in order to get intellectual protection of your creation or invention. Now, what is really a patent? Well, basically, it's a set of rights that are granted by a state, such as the United States, in this case, to an inventor or an assignee for a certain period of time in exchange for public disclosure of the invention. One thing not to forget is that the patent is territorial. Basically, it covers only the country in which you find your patent application. But the disclosure will be global, meaning that the public elsewhere in the world will be able to access to the US Patent and Trademark Office here in the United States and search for patents that have been registered with the office. Another thing is that the scope of the patent is limited by its claim, meaning by the content of the patent application. That means that if later on you're improving your invention, you will need to file a new patent in order to add a claim. Regarding the different type of patents, the first one and the most common is utility patents, which protects the way an invention works and the way it's used. So it could be a machine, could be an article of manufacture, a process. The duration of the protection is 20 years from the filing. Then you also have a design patent, which protects the way an invention looks like. Can be ornamental design in jewelry, furnitures, beverage container, like, for example, the Coca-Cola bottles. And the protection for this type of patent is 14 years from the date of the grant. And then finally, there is as well patents for plants, which protects asexually propagated plants by other means than that seeds. For example, you can think about GMOs. So what are the benefits, basically, of spending so much money and time in getting a patent? Well, first, as the owner of a patent, you will be able to prevent any third party from carrying out your invention, meaning like you will be able to use it, sell it, manufacture it, market it. And this will be an asset that you can license or assign to third parties in its entirety or in parts. As an asset as well, you can use it as a collateral for a loan, which could be useful. And of course, it's very attractive to have such patents if you're looking for funds from investors. Now, common question, what about if there are several people working on an invention? Who owns the rights to that invention? Well, basically, joint inventors share ownership of the patent regardless of the time and value of each one contribution. That means that each inventor can use it, license it, assign it, without the permission of the other. So that's very important that you think about having a contract in place to make sure that you cannot license it or assign it without the consent of all the inventors. This is not the case, for example, in Europe. In Europe, you need the consent of the other joint inventor in order to sell or license the patent. In case you do not have an agreement in place, Then in that case, if one of the inventors sell or assign or license the patents, then you won't be able to receive any proceeds from that sale or license. So very important to have a contract again. One thing about who can be an inventor. Well, just making suggestions or carrying out suggested steps from another is not considered being an inventor. You really need to be part of the inventive process. That's very important. Now, if you work for a company or if you're in partnership with a university, then you really have to look at the contract, which will tell you who owns the rights to your invention. Usually, if you work for a company, it's going to be the company, the owner of the invention and the patent. If you work in partnership with the university, usually there is an obligation to disclose to the university your invention. And then if the university decide not to proceed with a patent application, then they can allow you to do so. So very important to first look at your agreements, and secondly, if you have that duty, to first speak with the university. Now, what can be patentable? The first thing is the invention needs to be new, useful, and non-obvious. So regarding the novelty criteria, new means that there is no prior art, meaning that the invention is not known from the public. The exception, there is a grace period of time of 1 year, meaning that you can publish your invention in a newspaper, a scientific newspaper, etc. But you have to find a patent application in the US within 1 year. Just one note though, in the United States, there is now a new law called the America Invents Act that was enforced in 2013. And this act changed actually the definition of what is prior art. So you have to be very careful if you disclose or file in Switzerland first and then decide to file in the United States, or decide to file internationally through the Patent Cooperation Treaty called PCT. Now, another thing as well, don't forget that there is a duty of candor from the applicant and its attorney to disclose any prior art, meaning any prior patents on which your invention is based, or any adverse fact. For example, if you do any tests, data, and they contradict the results of the applicant. The breach of this duty means that your patents will be unenforceable. So very important to follow it. Now, gray areas. There's been since 2008, 2009 several court cases that states basically that softwares, business method, and diagnostic method are not patentable. One of the cases is Bilski versus Kapos, which is about a method of hedging risk in commodity trades, and basically the court said that it was not patentable because it was about an abstract idea. Basically, it was just mathematical formulas. Another case that the court decided very recently, Alice Corp versus CLS Bank, that just came out this summer, June 2014, where basically the court decided on an escrow software implementing a method for managing trading risk of financial instruments was as well not patentable because it was an abstract idea again. Now in the diagnostic method field as well, Mayo versus Prometheus, the patent was denied for a diagnostic method optimizing the drug administration to patients. So again, if it's mathematical formulas, if it's monitoring values such as pressure or temperature, that's not patentable. So you have to ask yourself, is it possible for a human being to do what the invention is doing? If the answer is yes, even though it takes much longer to the human being to do so, then it's not patentable. Now, the second question is, does the invention add anything to the human being process? If yes, then it could be patentable. So you have to be very careful. The last matter will be in gene and DNA registration, patent registration. The court decided that naturally occurring isolated DNA is not patentable, even though it's not DNA. As long as it's naturally occurring, it's not patentable. Now regarding international registration. Doesn't exist international registration, but you can apply to several countries sometimes at the same time. So first, the Paris Convention. What is it? Allows the applicants to file a first application in their own country. So for you, for example, in Switzerland, and then you will have 1 year to file the same patent application with one of the signatory countries and benefits from the date of the filing of your application in Switzerland. So that's one thing. The second one is the the Cooperation Treaty, PCT, that allows you to file a patent application in several countries at the same time. So you save a lot of time and complication. It's really good as well to delay costs and the enforcement patents, especially if you're not sure that your subject matter is patentable, because you have 30 months before the patent is examined by each country. So first there is a period of 30 months during which nothing happens besides the fact that it goes through the YPO. And of course, you can use as well the priority dates from your own country application through the Paris Convention as well, if you want to speed up the process. Now we're going to go through another area, which is trade secrets. First of all, trade secrets are not cannot replace basically patents. It's another protection, but it doesn't replace patent protection. It's to protect the commercially valuable business information that gives business advantage. Generally, those information are not known or reasonably ascertainable. They have to be preserved by confidentiality or non-disclosure agreements. You can think, for example, about the client list, the formula of the beverage Coca-Cola, business management information, compilation of information, for example. Now, this is a chart, basically, where you see the difference between trade secrets protection and patent protection. So, trade secret protection is useful because you're not limited in time. Basically, since there is no disclosure, public disclosure, you can continue to have the protection as long as you keep it secret. There is no registration costs, and the effect is immediate because you have no formalities. The cons is you cannot get any royalties from licensing because you have to keep it secret. There is no protection in case of reverse engineering, meaning someone else, a third party, find out a way to get the same results on its own without copying the information. And you would get only a remedy if the confidential information is obtained illegally. Now, patents, you have the 20-year protection that allows you to exclude any other from using your patent unless they get permission from you. You get remedy for infringements, but now you have to disclose the patent invention. And after the expiration, then everybody else can use it legally. Now we're going to go to copyright. One of the rights associated to copyrights is the right to copy, to distribute, adapt, display, modify, perform. Copyright is automatic upon fixation of your work, your creative work on a tangible medium. So it can be a piece of paper, it can be a USB key, it can be your computer, whatever you put your work on. And the registration is not mandatory, but there are a lot of advantages. We will speak about this later. The terms of the protection is 70 years, the life of the author plus 70 years. Now, what about joint ownership? Basically, for joint copyright owner, you have the right to use it commercially and exploit your copyrights on your own, but you have to share equally the proceeds of your exploitation. The C notice, the copyright notice, is not required, but highly recommended, especially because provide notice to third parties, and therefore you can ask for greater damages in case you need to litigate. Now, what about registration? We said that it was not necessary because copyright is automatic, but still, you can get statutory damages and attorney fees if you have registration. You will get as well prima facie evidence that you own the copyright. That's one of many advantages. The process is very simple. Basically, you can do it by yourself. You just go to copyright.gov in the United States, and you pay a fee of $35 if you already published your work or made it available to the public. You can as well have a pre-registration of the work if it's unpublished for $115. And you can get international protection through the Berne Convention. Now, as well in copyright, you have gray area. For example, logo. You could say that a logo is a piece of original artwork, even though usually logos are protected by a trademark protection. You have as well the question of fair use. Can you use someone else's copyrighted work without asking permission or paying royalties through a licensing agreement? Yes, it's possible if you use it for commentaries, criticism, parody, or educational purpose, but it's very limited, so very careful. Be very careful. Software codes, some people copyright them, but the protection is not that great because a third party could just only change a part of that software code, and the protection will not work if one of the part of the code is changed. People use it as well for web pages. For example, in the United States, we have juice fruit shops called Red Mango and another one called Jamba Juice. They used to be in a big fight one against each other because they were using similar colors and setup, and so therefore by infringing their copyrights. So if, for example, you're using a setup of colors display on your website, you can protect that by filing screenshots of your web page. Now we're going to go through trademarks. So trademarks, again, it's for protection of a word, of a logo, a specific sign that identify your service or products against the one of your competitor. Protection is for consumer protection first, but as well for your protection of your brand, for reputation and entry to the market. Now you have protection at the state level in the United States, but as well at the federal level. I would highly recommend, especially if your business is over the internet, to get federal protection for national coverage. Now, if you decide not to register, you still have what we call common law trademark rights, which means that you get protection for the geographical area that you cover. So, for example, if you have a bakery, then it will be in the area where your bakery is open and where your customers are. Now, if you are over the internet, then it could be broader. So you get a set of rights, but definitely registration is better. Now, for the duration, basically trademark protection persists as long as the mark is used in commerce. So that's very important to know. The protection is territorial. In most of the countries, it's from the filing date and not from the use of the trademark. There are treaties such as the Paris Conventions that allow the trademark owner to claim priority rights, again, from the dates of your filing of the application in your countries. And then if you want to apply in another country, you can use the filing date from your filing application in your country. You have as well international way to apply for trademarks in different countries, which is the Madrid Protocol to the WIPO. And you file one application for several countries at the same time, which saves you a lot of time. The term of the protection is 10 years. Then you have to file a maintenance with the USPTO between the 5th and the 6th year. And then it's renewable indefinitely as long as you use your trademark. Now, I wanted as well to go over licensing agreement because that's an important part for you to monetize your IP assets. Basically, what is a license agreement? It's the consent of the owner of the IP, the licensor, to the use of the IP by a third party, the licensee, in exchange for money or other type of consideration. It permits the other party to use, sell, import your IP rights, especially for patents and trademark, but as well to copy, display, modify, or make derivative works, especially for copyrights. So license agreement is important for the commercialization of your invention. First, if you want to license it to an industry partner, but as well, you could do a spin-off of your company based on the licensed technology. As well, it's important if you're thinking about a collaboration with R&D or industry partner to use what we call background IP. It's basically IP that already exists and you want to use it for improvement, or to use the research results and IP development developed by one party during the collaboration, which is foreground IP. Foreground IP is what you obtain during the collaboration. That foreground IP can be as well commercialized for another third party. So it's a good point as well. Now there is three parts in the license agreement. You have to be very careful when you read and review the license agreements, which are the scope of the grants, the financial terms, and the future development of the technology. First, the scope of the grants. So you have to define what you're going to license. And for example, if it's a patent, it's a good thing if you include the documentation, such as a copy of the patent application registration with the USPTO. Second thing, you have to describe the scope, the geographical scope of your license. For example, is it in the United States only, in North America and Europe? You have to define this. Another aspect is the license exclusive or non-exclusive? If it's exclusive, then your licensor will have the right to license it only to you, or at the contrary, if you're the licensor, you have the right to license it only to one third party, the licensee. If it's not exclusive, then you will have the right to license it to other third parties. Now, you have to decide what type of use or rights the licensee will have the opportunity to do with the technology, what channel of trade they will use, whether or not the licensee will have the right to assign or sub-license the contract to another party. If you don't want, it has to be in the contract. And whether or not you want any improvements in the technology to be made. Now, regarding the financial terms, the value first that you will get from the agreement is has to be considered, including all the terms of the agreement. You can have forms of payment, such as royalties, for example, based on the volume per unit or revenue percentage, but you could get a lump sum, an initial fee or licensee payment, installment payment, or a combination of all of the above. But you could have as well as valuable consideration, cross-license, for example. Now, future development of the technology. The first thing you have to remember is that technology will change over the time. It may improve, etc. But the contracts are fixed in time. So you already have to think in the future what could happen to the technology and whether there will be any improvements. Any improvement by the licensor or the licensee, joint improvements, what you will do with the products, who will own the new patents, who will take care of the service and support, especially, for example, for software. Is it the licensee or the licensor who should provide that service? As well, one other thing is grant back, which is basically a way at the end of the agreements to grant back the improvements of the IP to the licensor. That can be a partial consideration as well in the agreements. And to finish, this is a chart that I will let you go over, which summarizes basically what we talked about briefly in this overview. And you can go over it if you need to think about just what I said before. So thank you very much for joining us and staying with us. I will now accept any question that you may have. I think that we already have one, which was, I believe, what are the strategies to follow if a large competitor challenge your IP? Well, that first question is broad in a sense, because it really depends first of the type of IP we're talking about. Are we talking about patents? Are we talking about trademark or copyright? I would say if it's patent, my first question then will be, who is the competitor who is challenging your IP? Is it a real competitor? Is it a patent troll, for example? You have a lot of consortiums. For example, right now you get in the news consortiums from Apple, for example, and other big brands and companies against Google for violation of patents. So you have to know who you're fighting with. The second thing is as well, if it's a patent troll, you have now the American Inventors Act, who do not allow anymore patent trolls to file litigation against several defendants for violation of your patents if those defendants have nothing to do together with the violation of the patents, besides the fact that they're just violating each of them separately the same patent. So that's one thing you have to consider. The second one is whether you try to get in touch with your competitor or try to reach out an agreement with them in the past. That could be a possibility if you didn't try at the very beginning, such as getting a licensing agreement. Because the issue is that if the competitor is pretty big, then litigation is so expensive that if you're a startup, it would be very difficult for you to keep up with the rhythm and the fees, the cost of the litigation. So one solution could be to be absorbed, your company and your IP, by your competitor that is bigger. If it's trademark, for example, and you get involved in an opposition or a cancellation proceeding, then I would definitely try first, especially if your competitor is bigger than you, to try to get a consent agreement in order to allow you to continue to use your trademark or your logo, as well as theirs on their side. If they don't want, then it's, I guess, better to just not keep up with the litigation, because as well it's going to be very costly.
Diane, actually, thank you so much for your presentation and for answering that first question. A lot of nuances and very interesting facts to be learned. I also had a question which has to do with the duration of the patent application process with the USPTO.
Yeah, I didn't mention it, but actually the entire process of the patent application with the USPTO is between 2 to 4 years between the time you file and the time you get the final decision.
So it's a pretty, it's reasonably long, reasonably. It depends on your perspective.
It depends on your perspective.
Just a quick note, you can address questions, and we already have a few additional ones that have been logged on just a few minutes ago on our chat box. There's also the possibility of addressing us at Twitter. It's hashtag SwissNexIP. So that's also a way for you to try to reach us. One of the other questions we had to do with joint ownership. You talked about joint ownership in the US. Does it work in the same way in Switzerland, for example?
Well, basically in Switzerland, you have two types of ownership, which can be either joint ownership or co-ownership, or ownership in common. In the case of joint ownership, that means you have an agreement in place, and you will be able to sell, assign, license your patents, IP, for your portion only, and do whatever it pleases you. But you won't be able to sell, assign, or use the other percentage that your co-inventor owns. If you do not have an agreement in place, then it's a co-ownership. And in that case, what happens is you will need you have rights basically on the entirety of the patent, and you will need the consent of your co-inventor or co-owner in order to sell, assign, and license the patent.
And these processes, to go back to the timeline, do these things typically take a long time as well to obtain, or is it something that can be done relatively quickly?
Well, it depends on your relationship with your co-owner of the patent or your co-inventor. If they're good, usually that's the first step you do when you're working on the invention. Even at the very beginning of the process, you set up the way it's going to work and the splits, the percentage of each owner in the patents, in the invention. or you can do it during the process, but definitely that's something you should address in order to avoid a situation where one of the owner or joint venture decides just to exploit the patent without your agreements, and you cannot get anything out of the proceeds that you will receive.
Yeah.
So,
another question we have here, for prior art, what happens with all the patents that are not yet published as the priority is filed?
okay, so I'm just gonna, what happens?
So this is with prior art. What
Yeah,
happens with all the
the
patents that are not yet published as the priority is filed?
If they're not published, in that case, the first time the priority date will be the date of the filing with the USPTO. So if you don't publish it, there is no prior art. Or if, for example, you invented an invention, you created an invention based on another patent, in that case, that's prior art as well. And you need to disclose it to the USPTO when you file your application. But here in your question, you were talking about two things. One is prior art, and the second thing is the priority dates. But if there is no publication, then the priority will be on the filing date of the application.
Hmm. Another question we had from Chris is a U.S. patent lawyer good for communication with respect to the U.S. Patent Office versus, for example, using a EU agent?
Yes.
And for example, can your firm, Rosa Bianca, is that something that you...
Yeah, I definitely recommend to use a U.S. patent attorney to deal with the USPTO, because they know how it works. And behind the USPTO, you have human beings, you have examining attorneys, patent attorneys, who will take care of your patent application. And the examination will be done by human beings. So it's better if you are represented by an attorney who knows how it works in the US. Unless maybe the law firm you're using in Europe or in Switzerland is used to deal with the USPTO in the US, and that's fine. In that case, that's fine. Myself, I'm not a patent attorney, because this is another bar exam that you have to take. But we work with patent attorneys ourselves, and we deal with all the assignment and licensing of the patents, but not with the filing itself.
I have a question here about licensing. If I am a Swiss startup and own a US patent, I have a US subsidiary that is carrying out business in the US, do I have to sub-license the patent to the US subsidiary?
Well, you do not have to, but the question is, do you want to get, and how do you want to get royalties? Because sometimes licensing agreements are used to get a stream back of funds to the entity that owns the IP. So, for example, if it's the Swiss entity that owns the patents, and you license it to your US subsidiary, then the US subsidiary will have to pay royalties to the company in Switzerland. So if that's something that you want, then it's a good thing.
Actually, we have another question from the same user. It's about patentability. If I'm doing a patentability assessment and I carry out my prior art search, I won't be able to retrieve pending patent applications that are not published yet because they're still under examination.
True.
Will these prior art documents destroy my novelty in the US?
That's something there is nothing to be done about. That is true. That's it's, even though you do your job and you research whether or not there is prior art out there registered with the USPTO, you don't know until you file whether or not you will get a patent registration, because, as you said, there may be patent application under examination, and there is no way you can find out about it.
We have another question here. I have contacted a developer who works for another company. How can I protect my rights on the code?
So if the developer is working for another company, definitely I would start with a non-disclosure agreements. Depends if the person works as an independent contractor or is an employee of the company. If that person is an employee of the company, then the agreement should be with the company, and the company should have a confidentiality clause in the employment agreement or in the independent contractor agreement with that person. But definitely the confidentiality and non-disclosure agreement is necessary.
I'm wondering if we have any other question. I don't think we've got one right here.
Maybe on Twitter?
Yeah, we're checking our Twitter feed. The last question, I think we're good. The question I would ask you is, what are some of the most surprising questions that Swiss startups or have had that you were perhaps not expecting when you started working with them here?
Maybe the one I was not expecting was, can I protect my concept? I got a lot of questions about people thinking that once you find out of a concept, for example, you're going to do e-commerce, but you're going to present it in a certain way, and there is certain features that you offer to your customers. Can I protect it? And actually, no, you can protect your trademark. You can protect the way it looks with copyright. If there is an invention, you can maybe protect it with patent, even though software is mostly not patentable. But the concept itself is available to anybody, so to your competitor as well. Yeah.
So a lot of issues that people have to bear in mind when they're thinking about the concepts that they come up with, and sometimes it can escape immediately the startup that's working on these issues. They get caught up in the excitement of creating something new, but it's always good to be mindful of these issues.
Yeah, and something I would like to add as well. We got a lot of clients as well who do not do their due diligence, whether it's for patents, copyright or trademark, and start to work on some projects and invest money and time and efforts into IP, whatever it is, and finally they get cut out because there is someone else already who registered the same trademark or a similar one or a patent. So be very careful. I would say that the most important thing is to do your search before starting to invest time and money.
Wise advice. Well, I think we've arrived at the end of our presentation and webinar on US IP rights with Diane Artal, an attorney with Rosa Bianca and Associates. Please know that you can view this webinar on our website as well as on the other Swissnex websites for Boston and San Francisco. We also have a rich schedule ahead of us in December with webinars from our colleagues in San Francisco and Boston. So you can see those details on your screen right now. Well, essentially that's it for us here in New York. On behalf of Swissnex and the CTI Market Entry Camps, I'm Oliver Haugen. You can see our contact details coming up on the screen shortly. We have had a great time fielding your questions here, and we look forward to speaking with you over this medium in the future. Take care and goodbye.
Bye.